All right, welcome everybody. It is 5 o'clock, and thank you for joining us on the Hawk Tank Speaker Series for 2025. Let me introduce myself real quick. My name is Eric Prosser. I'm going to be talking about key legal issues for entrepreneurs today. Let me tell you a little bit about my background. I'm a former librarian and instructor at Fort Lewis College. I was an adjunct professor for what was then the School of Business Administration. It was not yet the CAT School of Business. And in 2019, I left Fort Lewis and came down to Arizona State University, where I am now the head of the STEM division at the ASU Library and also a faculty associate in our technological entrepreneurship and management department at the Polytechnic School, which is part of the Fulton Schools of Engineering here. As part of my background, I have a bachelor's degree in physics. I also have a law degree, as well as master's degrees in library science and the management of technology. And so my background, other than being a librarian and an instructor, I've also worked at times as an engineer and also as a lawyer. And so let me begin just with a little disclaimer today, because we'll be talking about a few things today. One is if I'm making any kind of references to products or specific patents or trademarks, anything like that, I'm doing it for illustrative and educational purposes only. It's not an endorsement by me or Arizona State or the federal government or the Patent and Trademark Office or anybody regarding those issues. Also, nothing today is legal advice. I am not your lawyer. I am not a licensed attorney. I'm not representing you. So nothing here is going to act as a substitute for legal advice, which is provided by licensed attorneys who will hopefully at some point be assisting you kind of on your business and entrepreneurial journey. So what are we talking about today? We're going to cover three big items. One, I always like to start out with talking about intellectual property, because if you think about it, that's where a lot of our businesses start. They start with an idea, and that idea is, your first bit of property for that business. It is some sort of intellectual property. We'll talk about the types here in a moment. We'll talk about forming the business, things you need to think about, kind of the structures that are out there. And then we'll talk about some legal issues that may arise after you form that business and are starting to grow. If at any time you have questions, please feel free to pop them into the live chat on YouTube. I've got that up on one of my screens here, and so I'm monitoring that. There'll also be time for questions at the end of the talk. And so first, let's start off with intellectual property. That kind of idea that we all have when we're starting off with, a business. What's the problem we're going to solve, and what's our solution to it? And so the first type of intellectual property I want to talk about today are patents. Many times when we are creating something or inventing something or making a product, we're often focused on how can we protect it, right? How can we make sure we're the only ones in this space, able to exploit it, things like that. And so we do this by having a patent. And so what a patent is, it is a right. It is granted to the government, the United States government, to an inventor. When you have a patent, you are able to exclude others from making what your patent covers, from using it, from offering it for sale, or, selling it throughout the country, or even importing it from another country. A patent is good for a limited time, typically 20 years. There are some types of patents that are valid for less. We'll talk about those briefly. And in exchange for this exclusive right, what you have to do as the inventor is you have to make a public disclosure of the invention. You have to tell people what it is and how to do it. So what makes something patentable? How do we get a patent? Well, you have to meet a few things. One, what you're doing has to be new or novel, right? It can't be something that's been done before. That's right there in kind of the word invention, right? What you're doing has to be useful, okay? It has to be, it has to have a purpose. It has to be functional. People need to be able to do something with it. It has to be non-obvious, and we'll talk about that in a moment. But in general, what being non-obvious means is that if you took a skilled individual in the area of your invention and they looked at it, would there be a bit of, kind of, oh, I wouldn't have thought of that? Or would they look at it and just kind of go, well, of course, right? It kind of has to pass that sniff test in a bit. And then the other requirement, as we mentioned before, you have to have a written disclosure how you make and use that invention. So the two kind of ones that are hard to define up there are, how do you know if that invention is new? How do you know if that invention is non-obvious? And so what you would do as an inventor is you would look at what is called the prior art. Okay. So prior art is information that describes the invention. It's disclosed to the public, and it can include anything from the past, right? So prior art are prior patents and published patent applications. Prior art includes foreign patents, things that have been invented in other countries and disclosed there. Prior art might be things that are discussed in journal articles, magazine articles. They might be in books. They might be in catalogs. They might be out there on the internet, right? If we're looking at websites or databases or blogs or things on Substacks, they might be things that are discussed at academic conferences or disciplinary conferences. And they might be out there in scientific papers. Essentially, prior art is everything and anything that has been disclosed prior to your disclosure of the invention, okay? And you have to disclose all that and look at all that for your patent application. So types of patents that are out there, there are three main types of patents in the United States. The first is a utility patent. This is what we typically think of when we think of an invention, okay? It protects how something works, how it's made. It can be a process, a machine, an article of manufacture, a composition of matter, and those are protected for 20 years. There's something called a design patent, and this protects the way something looks. It's ornamental, not functional. These are good for 15 years. And then there are plants. A plant patent is very narrow. It protects newly invented strains of fruits, of flowers, and other hybrid plants. But the key thing is they must be asexually reproducing, such as through grafting. Plant patents are also good for 20 years. And so we've got a few examples here on the screen of a utility patent. Again, this is what we typically think of when we think of a patent. We have a design patent there for the Statue of Liberty. It was patented by Auguste Bartholdi, the sculptor of the Statue of Liberty, and we have a plant patent there for a rose. Plant patents are pretty interesting because they often have these beautiful full color drawings, but they are one of the more rare types of patent. And so what is the subject matter of things that can be patented? Well, we can patent a machine. This is something that, as you might expect, creates something else or performs a function, using technology. An example here is an automatic library system that will automatically pull books off a shelf and put them back somewhere else if you need them moved around. An article of manufacture is a thing, right? It's something that the machines make. It might have parts, but usually those parts aren't, they're static. They're not necessarily working with each other to do something else. An example here is kind of the magic 8-ball, your little toy. And then there's a composition of matter. This is, what we typically think of as, let's say, chemicals or mixtures, things like that. The example that I've chosen here is essentially the generic form of Zantac. Processes, business processes can actually be patented, okay? Now, there are a few things to remember that if you're doing a process patent, you can't just patent an idea. You can't just do a concept, a mathematical algorithm, something like that. There has to be more. So in a business process patent, what you're looking for One thing is a tangible outcome, and that means there has to be a clear, measurable result that provides some kind of real-world value. An example here on the screen is Amazon's one-click patent, where you can just click on a button and buy whatever you're looking at, right? The idea is, even though, there isn't necessarily something physical happening, they're using technology, right? Their servers, their software, their databases for you just to be able to look at something, click a button, and then you have to purchase it without necessarily re-entering all of your credit card information, things like that over again. That's real world value, right? That's a tangible outcome. And then, of course, the second thing that we need in a business process is there has to be some type of technological component that allows this process to function, right? It can be software, hardware, but something in the realm of technology. The technology itself doesn't have to be patentable. It can be something that's been out there for a while, but you do need that involvement for a business method patent to be protected. Now, patents can work together. Utility patents and design patents many times go hand in hand. So here we have, I believe it's called the Furby, right? And so there was a utility patent for the Furby because it had this motor inside of it. It could listen to what you're saying. It would say things back using a speech synthesizer. Parts on it would move. The eyes would blink. They could communicate with each other using an infrared link. And so there was this technological component to the Furby, which can be protected using a utility patent. In addition, the look of the Furby itself, right? The outside, the ears, the eyes, the fur, all of these things can be protected using a design patent, okay? Because that's what's protecting the ornamental version. And so you can combine design patent with utility patent if you have a particular product where you want to both protect kind of the nuts and the bolts, if you will, as well as the overall aesthetic. And then finally, fairly quickly, we really don't deal with plant patents that much, but I do just kind of want to discuss them. A plant patent itself from the Patent and Trademark Office, again, needs to be an asexually propagating plant. There are utility patents available that can deal with plants. That can be the genes, varietals of sexually reproducing plants, plant parts themselves, methods of cultivation, particular traits. And there are other ways to protect plants, such as seeds, tubers, and other asexually propagated plants, which is through the Plant Variety Protection Office of the USDA. So those are kind of three ways to protect plants. Let's talk about kind of the path to a patent, okay? When you have this idea, you don't necessarily have to apply for the patent right away, although we'll talk in a moment about what might start that clock. But you're going to have to at some point do an application. Now, the United States, as well as most of the world, use what is called the first to file method. That means that your priority on getting a patent is dependent on getting that application in first before anybody else does. We used to have what was called a first to invent, which meant if you were the first to actually kind of come up with it and start to actualize the idea, you could have priority by proving that. It's very costly. A lot of litigation costs proving that you came up with something before somebody else. There were other advantages for entrepreneurs, but right now we're with first to file. And so there is something called a provisional application. This is kind of a bare bones patent application that basically acts as a placeholder. And it says, you know what? Within the next year, I'm going to have a full patent application for my invention, but I want to file this now and get my foot in the door so that I'm first to file. Within a year, you have to turn that provisional application into what's called a non-provisional application, right? This is where the disclosure occurs and, basically the world can see it. If that non-provisional patent the application is eventually approved, you have 20 years of protection from the date of the original non-provisional application, okay? Not everything, patents now can take a while to get filed or granted. The last time I looked, the backlog was just under 2 years from filing to final decision on a patent. That may be longer now, based on, some of the things that are going on in the federal government right now. But again, that's a dynamic situation. But historically, it does take a while to get through the patent process simply because there are so many patents being filed. So, options, right? So when you invent something, you do have an option besides just applying for a patent. Okay. If you don't want to apply and make that disclosure, you have the ability to keep it secret as what we call a trade secret. And I'll go into that in a little bit more detail here in a moment. Or you can just disclose it. You could throw it out there, make it public, let everybody know what it is. It becomes then part of the prior art, you know. Ways that you can disclose an invention are simply by marketing it, by offering it for sale or actually selling it, sharing videos online of your invention and what it does, publishing the details, using the invention in public spaces, discussing it with others in a public forum. Okay. If you disclose a patent like that and disclose what is inventive about it, that starts basically a 1-year clock for you to file that non-provisional application. Okay. So be very careful about talking about details of patents or details of inventions that you may want to patent. You don't want to inadvertently start a clock and have that clock run out on you and then not be able to protect it later. Okay. So I mentioned trade secrets. So a trade secret, as you can probably figure out from its name, is something that is valuable because nobody else knows it. Okay. Classic trade secrets that are out there, the Coca-Cola formula, right? That's not been disclosed. It's secret to the company. The Colonel's 11 herbs and spices, also a trade secret. Okay. If you want something to be a trade secret, you have to take these reasonable steps to protect the secret. That can be as simple sometimes as not talking about what it is. It might be for the folks who are involved in production that you have them sign non-disclosure agreements. Talk about those later. It might be something, that whatever the formula is or the secret is, you're keeping it locked up. You're keeping it secure. Okay. Now, a drawback to a trade secret is if somebody legally discovers it, they independently develop it, they reverse engineer whatever it is you're doing, there's no protection. It's out there then. They can use it. You don't have that ability like a patent to, say, go to court and get damages or enjoin the use, things like that. So keeping something as a trade secret does allow you to potentially exploit it longer, but there's always this danger that somebody might, basically scoop you on it. And there's the requirement that you be very diligent about protecting the secret itself. We're going to move to a second type of intellectual property, actually third type, because we went over patents, we went over trade secrets. Now we're going to talk about trademarks. So a trademark is essentially a word, a name, a symbol, a smell, a color, or a combination of all these that distinguishes a good or a service and can identify the source of that good or service to somebody who's looking at it. A few examples are on the screen now. You'll see more as we go along. And so there's sometimes a confusion, especially when we're starting out a business, of the difference between what we call a trade name and a trademark. Okay. The trade name is the name that identifies your business entity, right? That might be what's on your articles of incorporation. That might be on a doing business as statement, a DBA statement that you file with the state or the county, depending on who you're doing it as. So for example, Subway, we've probably all heard of Subway sandwiches. That's a registered trademark. But originally, the company was not called Subway. It was called Doctors Associates, Inc. It was a company and, a corporation formed by a number of physicians who were investing in a restaurant. And so the trade name, their trade name was Doctors Associates because that described the business entity. But Subway was the trademark that described the mark, right? Or the product, the sandwich. And so the trademark identifies the goods and services. Now, you may have a trade name and a trademark be the same with, for example, General Motors. Okay. It identifies both the automobiles and identifies the company. But you don't necessarily have to have those two things be the same. So if you think about, I want to trademark my company name, you can't just trademark the company name without it being associated with a specific product or a specific service. So there are types of marks that are out there. There are word marks. Just do it. For example, the Nike slogan, right? We're protecting kind of that short little phrase, right? We associate that with Nike. It might be in a different typeface. It might be in a different font. It might be, presented graphically differently, but those words themselves, just do it, are associated with Nike. Logos, symbols, designs, pictures, these can also be trademarked. We have the Starbucks logo up there. And camera fell. There. And so other types of marks that are out there, color can actually be trademarked. And, we have the MasterCard logo there with the red and, the yellow circle. Other ones you might think of are, brown for UPS, that robin's egg blue for Tiffany. Okay. Pink for Owens Corning fiberglass insulation. Sounds can be trademarked. So the roaring lion of MGM, kind of the startup symbol for Windows, or the NBC, the chimes on NBC. These little snippets of sound can also be trademarked when they're associated with a product. Fragrances, smells can be trademarked. That little smell you get when you open up a can of Play-Doh, that's actually protected. That we associate that smell with that particular toy. Now, when we're talking about colors and things like this being associated with a product, this kind of brings us into kind of the classifications of marks. Trademarks are good for products in a particular, let's say, manufacturing area. Okay. And the core tenet and the core belief of trademarks is it's to prevent consumer confusion. So, for example, you may have heard of Dove chocolate. You may have heard of Dove soap, right? Two completely separate companies. But it's okay for them to both have a trademark on Dove because, well, one makes chocolate and one makes soap. And we hope you're not going to confuse chocolate for soap at any point. Okay. One that just came up actually recently is the Arizona Coyotes. The hockey team moved to Salt Lake City, and one of the names that they were bouncing around was become the Utah Yeti. And so they put in an application for a trademark, and it's still working through the process. But Yeti Coolers filed an objection to it. And you might go, well, how's somebody going to confuse a cooler with a hockey team, right? However, Yeti also has a trademark to use Yeti in conjunction with apparel, right? Because they put their brand on hats, on shirts, things like that. And a hockey team is, of course, going to want to use the trademark when it comes to apparel because they're selling jerseys, they're selling hats, they're selling scarves. And so that conflict, even though it's not necessarily in their core business area, let's say, that type of conflict is enough to sometimes defeat a trademark application. Anyway, what can we protect? Goods, right? Things. We can protect the things we make. We can protect services, right? Intangible things. So I've got Bank of America up there. Banking services are protected. FedEx is a trademark for a delivery service. We can also, protect these kind of collective agencies or co-ops like, AAA. Certifications, so LEED certification, Energy Star certification, GMO certifications, those type of things and their associated labels can also be protected using a trademark. And so why do we get a trademark? What is the benefit of registration? So if you register for a trademark, you are presumed to own that mark nationwide. Okay. You put it in an online database from the PTO. That gives notice to everybody of your mark. You get to use the little R symbol with the circle. And then if people start importing counterfeit goods, you can actually have US Customs and Border Patrol block the importation of those counterfeits and seize them. Getting a trademark here establishes your ability to get that mark in foreign countries. And it's a prerequisite for a federal lawsuit for infringement. Um, there are some counterfeit Super Bowl goods there on the screen. The NFL is a very, very, very litigious when it comes to protecting, their mark, the shield. They literally deploy teams of lawyers to Super Bowl sites, and are always looking for counterfeit merchandise, things like that, that haven't been licensed and are very aggressive about it. Now, I've talked about patents, I've talked about trademarks, and so um, I want to kind of talk about something that's available to you in Durango called the Patent and Trademark Resource Center. A Patent and Trademark Resource Center is a library that has basically made a commitment to the Patent and Trademark Office, and they are providing basically public access to products, to services, to training, to education. They provide reference assistance and outreach to the public. Okay. Their mission is basically to get that information out there so that it's useful, by folks in the public, by, not just innovators and entrepreneurs and small business people, but also school children. They do educational things and they support these kind of diverse intellectual property needs that the public has. There are a lot of locations, and hopefully you're noticing on that map on the screen right now, there is actually one in Durango. Yeah. At the Durango Public Library, they are a patent and trademark resource center. And so if you need assistance in learning more about patents and trademarks, learning how to use the patent public search to see what's out there in terms of other patents, or using the trademark search to see, hey, has somebody used the mark that I'm interested in? There are librarians there who have been trained by the Patent and Trademark Office and are experts at teaching you how to do that kind of search. And that's what they do. They assist you. They can teach you how to search. They can put you in touch with relevant resources. They can't give legal advice. They can't submit the application for you. They can't tell you or provide a legal opinion about, hey, is something patentable, right? And they can't do the search for you for a couple of reasons. One, it's kind of legal advice to do the search and say, I've done a complete search. But more importantly, in order for them to do the search, you'd have to tell them what that invention is. And if you tell that to them, remember how I said there's that 1 year clock? That might start the 1 year clock. So it's better for us as librarians who assist you to provide examples, to kind of teach you how to do the search, but we can't do the search for you. But having Durango Public Library there is fantastic because they've got this commitment from the Patent and Trademark Office. There's networking involved, there's this community outreach, and it's just a fantastic resource there in Durango for anybody to use. And you don't have to be, in Durango to use it. You can be from anywhere. And so finally, before I move on to copyright, which is kind of the final one, there is a question I noticed in chat, that Elliot's got an advocacy group to lower cell phone radiation, tangible outcome, real world value, asking, would that be applicable for a service or, a business method patent? I can't answer that question directly, right? Because to say yes or no would be legal advice. But what I would think about is, is there something specific about what you're doing that would be patentable? Or is this, if it's an advocacy group, is this something more that you would kind of want to protect your brand with and the type of information that you're providing? And maybe, again, trademark might be more appropriate. So as we'll get to later, the best thing to have for those specific legal questions is a good relationship, or maybe even a lawyer on retainer. But just keep in mind, patent, trademark, trade secret, and as we're about to discuss copyright, kind of all have these different realms where they protect things for you. And so the best thing to do is kind of, your business, your ideas the best, is to kind of see which it most aligns with, and then kind of explore whether that then is the best thing to do. Yeah, Elliot asked about the AAA patents. The AAA wasn't a patent. We were talking about that in conjunction with a trademark that AAA has their logo trademarked, and then they let folks use it. So they used local, let's say um, tow truck companies, things like that, that can put the shield on there. And so that gives them the ability to kind of control their licensing, control that brand, even though they're not necessarily what we might traditionally think of as, a for-profit entity. All right, let's move to copyright. So copyright is the last of kind of the four big, intellectual property regimes. And what copyright protects is what we call original works of authorship. Okay. The great thing about copyright is it exists as soon as you put something into what we call a tangible medium of expression. And that could be, something as simple as writing it down on a piece of paper, taking a picture of it, recording it, putting it into a file, right? Electronic storage, as long as whatever you've, put it down in can be later, excuse me, I knew it's coming. You can later reproduce it or call it up. It's something that can be copyrighted. Cool thing about copyright is you don't actually have to file anything or register anything. It happens at the time of creation. Copyright is literally the piece of intellectual property that everybody has. You all have a copyright in something. From the time you're 5 years old and drew something to put on the fridge at home, you draw that little sun and that house on a piece of paper. You had a copyright in that, believe it or not. Other things that can be copyrighted, choreographed works. Yeah, choreography can be copyrighted. Dramatic works, obviously literary works. Architectural buildings. Yeah, so the architecture itself can, commercial art, drawings, again, musical works, graphic works, things like this, motion pictures, music, sculptures, sound recordings. All of these are things that can be copyrighted. And so what can't we copyright? Well, we can't just copyright an idea, right? If you think about love, right? You can't copyright love. That'd be horrible if you could. But you can copyright a poem about love, right? So we're not copyrighting the idea, we're copyrighting an expression of that idea, okay? A recipe cannot be copyrighted, okay? So if you ever look at cookbooks or blogs that talk about recipes, you know why they always have a story about how that food affects them or how they came up with it? It's because that's the part that's copyrightable, right? The impressions of the food. But the simple set of directions, the recipe itself, not copyrightable. If you've got a recipe you don't want anybody else to know about, you've either got to keep it as a trade secret, right? Coca-Cola, KFC, things like that. Or, you got to patent it as a composition of matter and just be able to, kind of exploit it yourself for 20 years. Short phrases cannot be copyrighted. Okay. So just do it. Remember, we talked about that with Nike. That is a trademark. Short phrases can be trademarked in association with goods or services. But a short phrase, title, slogan, things like that, not copyrightable. Needs to be a little bit more expansive. And then titles. Titles cannot be copyrighted. That's why you see many times a lot of songs that have the same title. There's not things that we can copyright. And so if you're the copyright owner, you have this ability, you can display it, you can distribute copies, you can perform it, you can make what we call derivative works. So, say sequels. You can reproduce it, and you can allow others or prevent others from doing it. Okay. And And you get these as soon as you get that copyright. You don't even have to apply for it. Remember, you have this ability. However, if you do register the copyright, what you can then do is now use the courts to kind of enforce it, right? So it gets that public record of your claim. Um, if you're going to do an infringement suit, right? Somebody's using your thing and you want to get damages out of them, you can do that. And then, of course, if you're publishing something, it gets deposited with the Library of Congress. And so for us as business people, copyright, it happens, it happens organically, but the biggest danger that can happen, especially with small businesses, is we might be, let's say, going out and we want to, I want to make a website, right? And so I don't have money, let's say, initially to hire somebody to take pictures. So I just start grabbing pictures off the internet. Well, if those pictures are under copyright, hint, they probably are, and you start grabbing pictures and then somebody sees it, you're liable for infringement, okay, potentially. So be aware that whenever you're using anything creative, to make sure that you've got permission to do it or that it's not copyrighted and is out there in what we call the public domain. So to wrap up, how's copyright different from patents and trademarks? Copyright, again, is those original works of authorship. Patents protect inventions and discoveries. Trademark affects those words and phrases and other things that identify something as being a specific good or service. And just remember, in general, ideas themselves are not protectable, right? They're not. The expression is through copyright. The practical effect of it is through patent. The association with commercialization is through trademark, but ideas themselves, those are not protectable. All right. So we've kind of gone through a big chunk of intellectual property. I get a lot of talk about that because it seems like it's a disproportionate amount of this talk, but it's usually what people have the least amount of experience with. So let's turn now to kind of forming the business, right? Honestly, if you're out there and you're already doing something, in a sense, you've already formed your business. But one of the things to do when you want to go that extra step and you will have partners or you want to be an LLC or you want to be a corporation, I'm always going to recommend you get out there and find a lawyer. You can absolutely do these things on your own. There are definitely how-to guides on how to, work through all of this your own. But ultimately, at some point, you want to grow, right? And, things are going to get too big, too fast to figure out on your own sometimes. And so I always recommend, if you can, find a lawyer. Find a lawyer, find a lawyer. And how do we do this? Usually, local bar associations will have referral lines. Other folks that that you might meet through, entrepreneurship support groups or invention support groups, innovator support groups, network, right? See who they're using, who's recommended. Many times lawyers will come in and, talk to you and might even do some hot tank talks and things like that. But find out, check out their reputations, things like that. But one of the important things to do, especially as a small business person, when you're finding a lawyer, is try to find a lawyer who understands small businesses and particularly, the niche that you're in, because sometimes lawyers themselves have these connections, right? They have connections to venture capital. They have connections to, other businesses that might be complementary to yours. And so you really want to find a lawyer who can kind of be a partner with you, right? You don't want to just use them and be afraid to call them because their hourly rate is so high. You want to develop that working relationship with the lawyer, okay? And that means for you too, being a good client, right? It's important to be a good client. It's important to understand, hey, there are times where there are definite emergencies and you need to get a hold of, a lawyer, but the lawyer is going to have other clients. They might be in court. They might be in a deposition. Who knows? They may not always be immediately available, but good ones are going to give you that call back at their first opportunity. So just realize that, you want to find a good working relationship with an attorney. And so what you do that, you're going to start looking at what kind of business form do you want to have? How should this business look? And I've got a few of the most common forms up here. Sole proprietorship is exactly what it sounds like. It's one person, it's you. You're the one making all the decisions. You're the one that's going to have to deal with the tax burden. You're the one that's, bearing the costs, getting the profit. Okay. But literally, you can't have more than one person who's running a sole proprietorship, right? There's one boss, it's you. And when you're starting out a business, that might be how everything starts, just you with your idea. And then we have partnerships. Okay. Partnerships are anytime you've got more than one person. Partnerships do not necessarily have to be written down. It's a good idea if they are, but they don't have to be. Typically, in a general partnership, all the partners are, sharing the profits, sharing the losses, sharing the tax burdens, sharing liability, which can be important from a risk standpoint. But yeah, that's kind of what we call a general partnership. Now, you can formalize partnerships in writing, and I think it's a great idea to do that. And it's really a good idea to do that when everybody's getting along. There is no better time to find an agreement than when everybody kind of has the same goal. We always think, oh, this isn't going to go bad. Why would we need a written agreement? Well, it might go bad. Okay. Option number one, which is the best option, nothing goes bad. You guys go off and you have great, financial success. But option number two, which unfortunately happens more than we'd like to think of, is there's a hiccup somewhere. And it helps to have something in writing to assign responsibility, to form a framework to how do we resolve a fundamental issue that we might have about the running of the business. Another type of partnership is what's called a limited partnership. Okay. And this is attractive for folks who might want to invest in a company, but really don't want to be, responsible for kind of any of the running of the company. Limited partnerships usually need to be in writing. This might be something where, for folks just starting out, hey, I want to get a loan from my parents, and my parents want to put, let's say, $10,000 into the business, but they want nothing to do with it, right? You start a limited partnership, they can put the money in, they won't have any liability for the business's debts. And this is the important thing. Anytime you see limited, it's an ability to limit risk, it's an ability to limit liability. The trade-off is that those limited partners can't have anything to do with the running of the business. No business decisions, no authority, nothing. They're silent partners. They're in for the money. Okay. Other types of companies that are out there, limited liability companies, these are more formal. They absolutely do need to be formed in writing. They do need to be registered with the states, but they do allow the members of the LLC, in some cases, to have tax advantages. They have the ability sometimes to determine how they're going to take the money, the profits, and treat them as taxes. And then, of course, a corporation is probably the most formal type of business form, where you have, officers, boards of directors, shareholders, right? They're community owned, owned by the shareholders, but run by the folks who are doing the business. Elliot asked another good question. When I say find a lawyer, what type of lawyer do I mean? Great question, because finding a lawyer, I like to say, it's kind of like finding a doctor, right? You don't want to go to a brain surgeon for a heart problem. Um, but what I think of when I think of kind of finding a lawyer who does small businesses and business formation, this is almost like the GP, the general practitioner of lawyers, right? You want to find a lawyer who's, familiar and has done business formation before, who works with a lot of small businesses, but doesn't have any problem referring things out when expertise is required. So for instance, if you're doing a patent, your kind of GP wouldn't be doing the patent for you, right? They would actually go to a patent lawyer or a patent agent, somebody with expertise in patents to do it. If we were, say, going for, let's say, venture capital, right? You might have a specialized law firm or lawyer for that. But when I'm talking about finding a lawyer initially, you want to find that good general lawyer who knows when things can be handled in-house, knows when you can handle things, and knows when to refer it out. So best thing you can do is initially find that good attorney as a partner. And I mean partner not as a business partner necessarily, but a partner to work with your business who can help guide you like that. All right. You form the business, you got to grow the business. And one of the great ways we grow businesses, well, we don't like to think about is contracts. All right. A contract can be anything, right? A contract is just a legal agreement to do something. Okay. It might be, as something as simple as I have given you $1 and you will give me a pack of gum, right? It's a contract when we do that at a store. It's not necessarily written down, right? It's just implied from the fact that we walk up to the cashier and hand them $1 and, along with the gum, and then we walk out with the gum. Contracts can be oral. They can be, more often than not, we think of them of written contracts. But there are a few specific types of contract that I think you should be aware of, especially, when you're starting a small business. Number one, non-disclosure agreements. Okay. I talked about these a little bit when we were talking about patents and trade secrets, that non-disclosure agreements are a way to kind of put that little bubble of secrecy around what you want protected. But non-disclosure agreements might occur in other situations, okay? But don't rely too heavily on them. And here's my example for this. If you get to the point where you're starting to find, look for an investor and get some seed money or venture, you're looking for investment. When you do your pitch, more often than not, the VC folks, they're not going to sign an NDA. They're not going to sign a non-disclosure agreement. They hear tens, hundreds, thousands of pitches. And for them to sign NDAs on what might be 100,000, a lot of pitches, it creates an amazing amount of risk for them that somebody somewhere is going to come back and say, you stole our idea. Okay. So you don't expect NDAs at the pitch level. However, the trade-off is they're not expecting a lot of detail about whatever your secret sauce is at the pitch level, right? The pitch level is, here's a problem, here's our solution, here's the market, here's how we're going to be able to capitalize on this. Please give us some money. Now, when they get to their due diligence portion, right, when they're interested, when you've whetted their appetite, and then they really want to get in and see what's going on, that's the time for NDAs, when people are doing their, serious due diligence. But don't freak out if you go to a pitch and you want somebody to sign an NDA and they won't. It's fairly common, but it's good to know about them because it kind of protects that intellectual property that might be the key to growing your business. You want to lock up key personnel in writing, basically, if you can. So, non-compete agreements. So you don't want them leaving your company and immediately going to a competitor and, basically spilling the beans on what's going on. You want to make sure folks that are there are going to be there for, what might be a difficult period as a small business grows. Supply chains. This is always underscored by, recent history, is that many times it's important to lock up, especially if there are particular products or things that you need to make what you're going to make, locking up a supply chain. And that can be locking up a price. It could be locking up the supplier itself, right? And making sure you have the thing, even if the price of the thing is changing in value. It can be both. Licensing contracts are important. Sometimes, let's say we get a patent, but in order to make what we're going to make, we need a capital investment of several $100,000 because we need a manufacturing center. Or we can license idea to somebody who's already got the factory, right? They can make it. They're going to profit off it. We're going to profit off of it too. But many times licensing our ideas, licensing patents is an amazing way to actually get better return on what you're doing, even though you're not necessarily getting the lion's share of everything. And so I think these kind of 4 types of contracts together NDAs, locking your key people up, supply chains, right? And that goes both ways, right? Being able to supply your product to people exclusively or have minimum buy contracts, things like that. And licensing, you license products, you may license your product. And so I've been talking now for about 50 minutes. That's usually kind of a good introduction to everything. So I'm kind of stopping my presentation there. And if any of you have any questions, feel free to throw them in the chat. If you have any questions for me, you can always email me at eric.prosser, eric.prosser at asu.edu. Or you can reach out to Dr. Valdez or anyone else at Hawk Tank, and they can get in touch with me as well. But other than that, let me know if you have any questions. Thanks. I'll give about one more minute if any of you have some questions. I know sometimes it takes a while to type them in. All right. Well, thank you very much. I appreciate being able to do this. And again, if you have any questions, feel free to reach out. And best of luck on your hot take journey. Thanks very much.